Tonight, a stalking case has people wondering about their First Amendment rights. Justices ruled in favor of a man who had been convicted for sending a woman messages that were deemed threatening.
Okay, so questions now about whether this will change how stalking cases are prosecuted in the future. Ariane Day-Till digs into the court's ruling.
From 2014 to 2016, Billy Counterman sent hundreds of Facebook messages to a local Colorado musician. Messages that the musician said made her fear for her safety. In 2017, Counterman was found guilty on charges of stalking and harassment and sentenced to more than 4 years in prison. Counterman appealed the verdict, saying his First Amendment right to free speech was violated because he didn't know that the messages were threatening. In June, the Supreme Court agreed and reversed Counterman's conviction. The ruling immediately prompted people on social media to ask if the court's ruling means stalking is now protected under the First Amendment. So let's verify. Our sources are the Supreme Court ruling on Counterman v. Colorado, the Free Speech Center at Middle Tennessee State University, and Clay Calvert, Professor Emeritus of Law at the University of Florida. The First Amendment protects an individual's right to free speech, but it doesn't protect something called a true threat, and that is exactly what this Supreme Court case focuses on. According to the Free Speech Center, a true threat is a statement that is meant to frighten or intimidate someone into believing that they will be seriously harmed. Counterman argued that he didn't know what he was saying was threatening, so it shouldn't be considered a true threat. Instead, it should be considered protected speech, and the court agreed. Under the Supreme Court's new ruling, a prosecutor has to prove to a jury that at least one of the following is true about the person accused of stalking or harassing somebody and the messages they sent. The person intended to make the threat, the person knew the statements could be perceived as threatening, or the statement could be perceived as threatening by a reasonable person. According to University of Florida law professor Clay Calvert, while this ruling doesn't stop prosecutions of stalking cases, it could cause a domino effect, because any defendant in a case involving harmful or threatening speech could claim they didn't know their statements were threatening or being perceived as threatening. So we can verify, no, the Supreme Court did not rule stalking is protected under the First Amendment. With your Verify, I'm Ariane Day-Till.
And if there's something you'd like the Verify team to check out, you can email verify@12newsnow.com or you can direct message us on social media.